Okay, this is American Liberties. My name is Chris Chapman, and I got Richard Boggs on the call with us, as well as Master Royal, also known as Lamar Hardy. And before we get started to David Myrland's rant, let me give you a little background on the people, including David, who he attacks with his lies and his twisted mind. David Myrland is apparent. It is apparent we all suffer from David's grandiose narcissism. Um, it's obvious as it is defined: high self esteem, a sense of personal superiority, and entitlement over confidence, and a willingness to exploit others for self gain, other hostility, and aggression when challenged. That fits David's personality to a T. Now, Lamar Hardy is the founder of the executive director who had been extremely successful helping people with tax issues as well as other things. But in fact, he was so successful, the government had to get rid of him to the point of literally railroading him to prison. And that is another story of itself. We don't need to go there. But Richard Boggs, who lives in South Carolina, who recently got convicted of 5 counts of tax evasion, Richard has known David since 2012, maybe a little before, a little after, and has helped David financially at any time when David asked for help, never refusing, but always willing to give. And I say that for what you're going to hear later in David's remarks. Me, Chris Chapman, also known as Chappie, I've dealt with David since 2005. And prior to this time, I was a member of many groups, Save a Patriot, ARL, and the Lawmen. But the Lawmen headed up by a guy named Chuck Consus, who had a pretty good criminal complaint template. And I sent that to the FBI as well to all the judges in Central Florida. When I was introduced to David, after a brief discussion, which I was impressed by his posture. It's not so much of what what he had written, or his knowledge of the tax code, but his posture. I got that right away. So I joined his criminal complaint to Congress, which has an outstanding memorandum of law, which is very important to this conversation that you are listening to now. And I sent that as well to all the judges in Central Florida. Soon thereafter, I received a subpoena to go before the grand jury because I was getting investigated for tax evasion. Basically, this is where it all began, which I'll be showing you forthcoming. At no point in time did I ever not recognize David's gift, intelligence, and his writing skills and his ability to argue. Oh my God, he loves to argue. That's his forte. If he can't beat you in if he can't beat you with his arguments, he'll start, calling and trashing you, your personality, your trashing you as a human being. He sounds like one of these leftists. If they got no argument, they just throw names at you. And again, arguments are for fools. What many of us, like Richard, Lamar, we all have in common, we don't argue. And this is relevant to what you're going to hear. I was preparing a response to his false allegation. Oh, I repaired a response to his false allegations. The subject matter of his rant is found in Memorandum of Law beginning on page 21 through 23, Title B. Respondent wants for requisite statutory leave to operate. Okay, so now let's listen to the recording, and I'm going to stop on several points that he makes.
It's April 26th, 2023, a Wednesday. About 90 days ago, a guy I've known for 15 years, 20 years, Lamar Hardy in Hawaii, who ran the Research Foundation. I sold professional opinions through his foundation for his clients, to his clients, notarized opinion letters about how the tax code operates, and I had about 3 or 4 different letters on file with him for sale to his clientele. And in the Boggs case, about 90 days ago, without even speaking to me about it, he and Richard Boggs talked things over and decided that motion I had written should be done a different way.
Now, I want to stop there. David fails to mention, in fact, he never brings it up. He fails to admit that he was at his end. He didn't know what he could do anymore to help Boggs. He was in a dilemma. And so he had talked to Boggs, and now I'm assuming this because I didn't know after the fact, but David called me and he said, look, I'm suggesting that Boggs hires Lamar Hardy. And I said, oh, that sounds great. He said, yeah, because Lamar has over 300 wins. He's very successful. And I really don't, and he has an affidavit process that he uses. He's more into the commercial aspect, which we all know that David isn't, and so forth. And I said, great. So then Richard and Lamar have a discussion, which I wasn't a part of, and they worked out a deal and yada, yada, yada. And so then we had a conference call. Now, at that point, we were having conference call meetings. Just, after that, they got together, Richard and Lamar and David, and then me. And David was mainly, in my mind, again, I'm not making any accusations, but David was going to be the writer. Lamar was going to give his expertise, and me, I was a soundboard for Richard, because Richard's under a lot of stress. I've been where Richard is, and with my if you want to call it expertise or experience, I felt like I could be a benefit to Richard in giving ideas. Now, I may agree with Richard on what he wanted to do, but I would play the opposite role, not even him realizing that I was, just to make sure that he's thinking everything that he was doing. That was basically the job that I took on. Now, I don't know if Lamar, I don't know if David thought, hey, what is Chris going to do? I don't know. And I really didn't care, because my focus was to help Boggs get through this, because Boggs has helped me over the years too. And I'm not getting, and like David will be whining, "Oh, I didn't get paid. He never paid me." Well, that's a lie. And in addition, I got paid long in advance when Richard was there to help me when I needed financial help. So that's where it lies. So let's go on with the recording.
And I texted Lamar in Hawaii. I said, you read up when you consulted with Boggs. And the next day, I told him, we don't associate, and I hereby drop the case that you have me in Hawaii. So, terminated it. Haven't spoken to.
Okay, so now, I don't know how David texting Lamar. However, he did have a conference call, and David was very rude and nasty to him. And all of us, Richard and I were, thinking, and Lamar, but after the call, thinking, what happened? Because we were all in a, in fact, I don't need this here. This could be just my note, because I'm clearly going off the notes here. But David would bring up a suggestion, or let's do this and this, or he'll write out a brief and then send it to all of us for our input. Not to change anything, but consider this, consider that. Let's do this, let's do that. And we all had a great discussion. And and we talked about it. And maybe Lamar had an idea and David didn't want to do it. And I might have thought about it and added something to it. But at the end of the call, at the end of the meeting, we knew where we wanted to go, where we were going. Maybe I didn't get what I wanted. Maybe Lamar didn't get what he wanted. And maybe Dave didn't get what he wanted, but we didn't know he was going to go inside of his room and kick himself. We didn't know how much he was tortured that he didn't get his way. But the fact is, we all thought we were having a great team, and we were enjoying it. So let's get on with the recording.
Spoken to him since. Cool. Because the strategy in U.S. District Court, and this is I told Kurt Riggin today about it, and he immediately laughed at the complaint that I had because he could see how stupid people had acted. Well, I was writing a motion, and Lamar teamed up with Richard and said, no, it should be done this way. Do it this way. And so I dropped Lamar, and I told Richard.
See, there again, I wasn't privy to conversations that he had with Kirk. However, if he lied to Kirk as he's lying on this recording, of course he's going to laugh. At no time on any of the calls did anybody, including Lamar, said it's got to be this way, it's got to be that way. No, it's got to be that way. The only one who did that, I'll give you two guesses, and the first one you're going to be right, is David Myrland. He's the only one that said, no, it's got to be this way. And we all shut up. So, again, he's twisting his false allegations. Anyhow, let's go on with the call.
Here's why. First, you shut the government's mouth before you give them the evidence. You file a motion that might be scant and it doesn't have the exhibits or the evidence attached to it, and then you get their reply, and then you sandbag them with the evidence now that they can't open their mouths again. So Lamar's history. And here we are in the Richard Boggs case, where there's a motion for acquittal before the before the sentencing. He's already been convicted of 7 counts of tax evasion.
Okay, again, I want to repeat, he's talking about Lamar's history. History from what? The case he was doing for Lamar in Hawaii? Or is it history because Boggs hired him and David now has the authority to drop Lamar? I mean, think about it, guys. I mean, it's just it's ridiculous. it's like, uh, it's like ridiculous. I mean, how it's so ridiculous. How can you even respond to such a thing? You know, Lamar has an affidavit process he can't beat. And, you know, and subsequently, I didn't learn it from Lamar. I learned it myself all through the years that it's a, you know, here's the evidence, dispute the evidence. If you don't have any, if you can't rebut it, what happens, guys? The claim fails. It's gone. It's history. And that's Lamar's way, and that was my way, which you're going to be seeing some of the filings we're talking about on this call. But to be brief, I want to keep the call going. So let's go.
Believe it? It's April 26th, 2023, a Wednesday. First, you shut the government's mouth before you give them the evidence. You file a motion that might be scant and it doesn't have the exhibits or the evidence attached to it. And then you get their reply and then you sandbag them with the evidence now that they can't open their mouths again. So Lamar's history. And here we are in the Richard Boggs case where there's a motion for acquittal before the before the sentencing. He's already been convicted of 7 counts of tax evasion. And Rule 29 says the judge can...
Here's a guy who talks about he's so engrossed into the paperwork and the pleadings and everything, he's only convicted on 5 counts, not 7. But, and I'm just being, I didn't have to add that to it, but, you know, but being David is so perfect, why not?
Set aside the conviction if the evidence weighs heavily against it. Well, his attorneys, 2 criminal defense lawyers that were paid handsomely, didn't expose his record to the jury. All that litigation, 9 lawsuits he was a plaintiff in.
David is correct. Those attorneys, if they could be charged and convicted, they ought to be. Richard had a an absolute phenomenal stack of evidence that would clearly, with no doubt, prevented a guilty verdict. In fact, a lot of his evidence was non-rebuttal and failure to reply to a conditional acceptance based on territorial jurisdiction, which more of that will be coming up.
And his attorneys didn't even use that to prove he doesn't believe he has a duty, which is one of the elements of willfulness. And so if you're not willful, you're innocent. And they didn't represent his record to the court or to the jury. So when he fired his attorneys, maybe 4 months ago, he went on an affidavit campaign, and 4 successive affidavits remained without refutation, unrebutted affidavits. And then those were all filed behind his first offer of proof. And then his second offer of proof was a submission of all 9 of his sworn lawsuits. That was the evidence behind the second offer of proof. The third offer of proof, I think, was about the 5K2 rules on if these criteria exist, the judge can enhance the sentence. And if these criteria exist, the judge can reduce the sentence, downward departures. And then offer of proof number 4, I think, was about entrapment by estoppel. And he filed a motion for acquittal that had legal arguments in it, like Section 83, and citizens of the U.S. are only named in regulation, and a couple other arguments like clear language.
Okay. Now this is this is my opinion, basically. Okay, well, just cut in. The I'm sorry, I got a text and it broke my train of thought. They brings up that, you know, about Section 83, which is a great argument if you're a citizen of the United States. And when I say that, I mean by a citizen of the federal United States. Now, David's website shows all the circuit courts that held a conviction on a citizen of the United States. Why? Because one, it was in an Article 4 court. Two, the attorneys, and oh, by the way, the Article 4 court can only force rules and regulations in their territory, which is the District of Columbia. The attorneys, by definition, can only, you know, are from the territory, the District of Columbia. The criminal code is for the territories, not for 50 states. And the Federal Rules of Civil Procedure as well is for this territory. So here you got a whole band of federal regulators that are convicting somebody through the regulations, as if, okay, I mean, this is what happens. Roy, you got something to say? You need to unmute yourself. Okay, hold on a minute, people. We got a little brain cramp here. Okay, unmute yourself, and if anybody, you know, just break in. Don't wait to. I'm gonna pause the video for a minute. Okay, Roy,
Yes.
you wanted to say something?
Well, first of all, I mean, I would have liked to have talked about, you know, things at each interval of those breaks, but the bottom line is simple, you know, with me and David. You know, I've had a relationship with him for almost 30 years. And the difference between me and David is I've consistently won cases all across the country. The fact is, David's never won one case, okay? And there's very few people out there that have won any cases. So you have to look at why David had respected me for 30 years and why he was a part of my program, because he could see that what I was doing was winning cases consistently. Now, I didn't win it with, you know, the typical type sovereign arguments or those type of things. I won my cases based on using affidavits and using a reliance defense method. And this is a method that anybody can use. It's very simple once you understand it. And my booklet, anybody here that wants to have access to my booklet, you can call Chappie. He can send you over a copy of my booklet. Read my booklet. All my victories are listed in that booklet. And the format and some of the understandings, the affidavit part of it isn't in the booklet, but the basic understandings of the technology that I use. I've also won many, many bankruptcy cases, probably about 150. According to the government, I discharged over $280 million in bankruptcy. Now that's a record. No one else has ever done that, okay? So there's a reason that David worked with me on all these things. And up to this point, David never, ever said anything discongruent about me. He always said good things about me. In fact, when I got into this case with Boggs, I didn't know about the Boggs case. Data had been working with Boggs for almost 10 years on this case, on the Section 83 arguments. Data called me after Boggs was already convicted. So here I am facing a case where a person's already been convicted of the 5 counts of tax evasion, and I'm asked to come into this case at that point in time and assist Boggs, which is a very difficult position to be able to assist somebody that's already been convicted. I mean, think about it. If you know of anybody that's been convicted out in the entire industry, how many people have ever won after they've been convicted? I don't know of anybody that's ever done that. But at this point in time, because I'm coming in, I come in and I immediately started using my affidavit process. And by the way, David Myrland didn't know anything about the affidavit process. He's never written an affidavit an affidavit the way I wrote them. And so all of the affidavits in Boggs' case, Data attempted to write and draft them, but he did it based on me sending him copies of my affidavits. So the beginning part of the affidavits, whenever it came to be a part of the affidavit, came from me. And then I corrected him when he made mistakes all the way through the whole thing. And he got pissed off because I corrected him. Well, if I had left it the way he did, there wouldn't have been any substance to the affidavits because it didn't close. David doesn't know how to close any deals. He doesn't know how to close the case. The affidavits, the purpose of the affidavit is to close the case. It's to get the government in a position where they acquiesce, where they agree by their silence. And this is standard procedure in any type of civil cases and in criminal cases, right? You've got to get a person to the point where they go silent. Once they go silent, that means they're acquiescing. It means there's no argument between the parties. And when you do 3 affidavits and that happens, you get an unrebutted affidavit. And when you get the unrebutted affidavit becomes the judgment in commerce. Case closed. I happen to do a 4th affidavit, which is what I call my willful affidavit, which lays out the criminal aspects of the case in which the parties, the original parties of the case, the United States and their U.S. attorneys committed crimes against the individual. And so I lay all that out. And in Boggs' case, they also acquiesced to that. So Data didn't like me coming in and doing this. But the problem is, when I came in, David told me, he says, I don't know what to do. He's already been convicted. I'm done. I can't do anything more. That's why I'm bringing you into the case. So think about that. Here's a guy who says he's the expert, been working with Boggs this whole time and providing motions and briefs and things to support him. And when he was supposed to come and really help support Boggs by being subpoenaed, he was subpoenaed to come to the case. He didn't show up. I mean, here's the expert who didn't even come to the trial to show up to defend the position on the Section 83 argument. So unbelievable that he wouldn't even come and defend his own client. So I came in at that point in time, put together the affidavit format, and I assisted the team. And when I say team, I'm a team player. Boggs is extremely intelligent. He's a really, really good client. It's a lot of fun to work with him. And Chappie's got years and years and years of experience, not just with David Myrland, but with all kinds of other people, and brings a lot to the table. So the purpose of me coming in was not to be a bully or someone to say my way or the highway. No, I was brought in to be a team player, to work with everybody and allow everybody to participate in everything I've done for the team. Boggs has come in and he has looked at everything that I've done. He's made his own determination of what he felt of how the words were and how I put things together. He made a lot of corrections in the way he wanted to say it. Chappie also always put his input in. And I evaluated all those inputs, and you know what? I yielded on a lot of it because you know what? These guys are intelligent guys. They know how to play. It's not as if they don't understand what the game is, but the way I set it up, it's a lot simpler to understand. And like Chappie says, it's not about arguing. It's about setting the case up so you can win. And I've spent a lot of time with these guys. I admire Boggs. I think he's got a lot of courage. I think he's got a lot of conviction. And you know what? He's highly intelligent too. Maybe he doesn't know everything, but you know what? When you give him the framework and he sees what's going on, he is very, very intelligent. So is Chappie. I mean, we're talking about some good, serious people that have got a good heart. I really love working with both these guys. I'm certainly a team player. I'm not saying I know everything, but I certainly can lay the foundation down and put the thing together. And by the way, here we are in April when Boggs was supposed to be sentenced in January. So obviously we're doing something right. And we've got the government in the position exactly where we want them. We filed the 4 affidavits. They all acquiesced to that. And that affidavit process is going to be utilized here very soon. We're also bringing up the territorial jurisdiction issues, which are highly important in criminal tax cases. And David Myrland doesn't want to even touch us with a 10-foot pole. And I'm shocked. Out of all the things that we can put into the case, the territorial jurisdiction is probably the most strongest item that we can use legally, as well as the affidavits. So I think that's a little bit of the background, a little bit of the history. I do admire David for his intelligence. He is a sharp guy, but for whatever reason, he's not a really good team player. And when it comes to a criminal case and a situation we're in, we have to be humble. We have to be approachable. We have to use all of our skills, all of our talents. Everybody works together, and we have to use stuff that works, right? And the difference between me and working with David is the technology that I've worked with has proven itself over years and years and years of experience in the courtrooms, winning cases consistently. And that's a big difference. I'm not about arguing. I'm about stating the facts, about setting the case up and getting the thing dismissed as fast as possible. So I think that kind of updates my position and where I'm coming from. If any of you out there are listening to this, I recommend that you get my booklet. Boggs or Chappie can send it to you. Take a look at my work. Look at the setup compared to everybody else you've ever seen out there. Look at my victories. Look at the reason why I'm winning cases. There is a reason, right? And the reliance defense is extremely powerful. The affidavits are extremely powerful. You don't have to be a sovereign. You can just be you, and they still work in court. So I think that brings us up to date. Chappie, is there anything else you want to add to that?
No, well, I'm just going to go on with the rest of David's recording, and we'll end the show.
Okay.
All right. Okay, and okay, let's go.
Void for vagueness, legal issues. And then the second motion was about, I can't remember. Third motion, entrapment by estoppel. And I wrote that. And then he emails his draft of it to me, and it's got a bunch of mistakes in it. He included a bunch of exhibits in it that I didn't list. I tried to write it so it was very scant, so you can get an argument out of the government that wouldn't be too complicated. And then you respond with all the evidence and you bury them with it. But instead, he put all the exhibits in the first of that trio of pleadings, where you file a motion, they file a response, and then you write a reply to the response. So they put all of the evidence attached to the first motion in that trio. Don't do that. If you want the government to challenge all of your evidence, put your evidence on the record. Well, don't do that. You wait until the government has lost its opportunity or spent its opportunity to reply. Then you sandbag them. No, I'm Chris Chapman. I'm going to interfere with Dave's law office and talk with Richard Boggs, and we'll revise that motion to put it all in the motion.
Okay, here again, now this is the first time in this recording it brings me up. And I had nothing to do with it. Do I believe in territorial jurisdiction to be argued? Absolutely. Did I push or convince Boggs to do it? No way, because Boggs, which you'll see later, understood the territorial jurisdiction and argued it back in 2018 And in this conditional acceptance letter, which they failed to answer, which the attorneys refuse to enter into the record as evidence. Why? Because they're part of the territory that is coming against Boggs. It's all there. It's right there. But David does not want to recognize it. And the sad part of it is Title 4, Section 72 comes right out of David's book. So go figure. Next.
The first one. So my strategy.
Does somebody want to say something?
Yeah, first of all, he talks about his law office. Yeah. And by saying that, he implies that maybe he's an attorney or some type of expert in this. First of all, he doesn't have a law office. He's just a common law researcher like all of us. And he has a little bit of legal expertise. Yes, he does. We'll all admit that here. But the problem is, let's look at his record. He has never won one case. So if you were going to choose somebody to come in and assist you to handle a case that's never won a case versus someone who has consistently won case after case, hundreds of cases, who would you choose? And isn't it interesting that David Myrland would not bring me in when he knew of me the whole entire time with Boggs? He didn't dare bring me in once. He brought me in after he was convicted. Now think about that. Mm-hmm. Why would you bring somebody in afterwards? When he told me, I don't know what to do, he's already been convicted. Why would you bring someone of my stature who's consistently won cases at the end of the case after the guy's been convicted? Wouldn't it be much more intelligent to bring me in the beginning and help strategize? And as far as providing a lot of documentation on the record, like he says, that might be one strategy, right? But at the same time, I've never done that. I've always put the stuff in the beginning.
Yeah.
And I've always saved something for the next round. But I want to put my strength. I want to show who I am or what my client is and what his position is right up front.
And you know give them the opportunity to rebut it.
Yeah, and you know what my experience has been? That they can't rebut it. Exactly. If you really have the truth, if you know what you're doing, if you know how to write, the government has no response. And then what you do is you do an affidavit of non-response, right? And just nail them on that. And again, David doesn't understand the affidavits. Maybe he does, maybe he doesn't, but he's never shown me in this history that he knows how to use them properly. So, you know, he has a way of doing things. And you know what? God bless him. He's done good. I highly respect him. I honor him. And that's why I've always been his friend for the last 30 years. But at the same time, you have to bottom line look at the record. What is, you know, how many victories do you have in your notch? I mean, I can claim all of mine because I know who they all are, right? And I've won all of mine in trial, right? Trial after trial after trial after trial, case after case after case after case, consistently. And I don't know of anybody out there that has a record like mine. I've never seen it. I mean, if there is, show me the person who's been doing it. All I can show you is what I'm doing.
You know, because you're saying all that, a lot of people are going to say, hey, how can I get a hold of that guy? You're no longer doing this. Am I correct?
Yes, I'm 67 years old and I'm winding down. I would be interested in maybe doing some consulting work, but you know, like you, Chappie, I'm looking for a retirement. I mean, I've been doing this since 1985 to the present. Yeah. And my brain is fried. I mean, I'm really worn out, but I certainly would be interested in a consulting basis. But at the same time, I'm really not interested in doing a whole lot more work on this because I'm actually pursuing other ventures right now that are really equally as important in the global aspect of what's going on.
Mm-hmm. Okay, let's go on with the recording. And
doesn't count. They didn't even contact me about the changes, and they made the pleading look stupid, amateurish. That's the first thing the judge is going to say when she sees this. In the first paragraph of that motion on entrapment by estoppel, it says right there, offer of proof number 1, 2, 3, and 4 are incorporated by this reference as if fully restated herein. Then they list the exhibits, offers of proof 1, 2, 3, and 4. Why would you include as exhibits something you've incorporated by reference? That's pretty stupid. Well, it's okay. I'm Chris Chapman. I'm going to mess with Dave's work, and we aren't even going to tell him about it. And Chris knows that 90 days ago, Lamar Hardy did that, and I terminated our friendship and association and dropped the case that he had me in. So Chris knew that's what I would do if he chose to interfere in a case that's in my office. Richard didn't go to Chris for help. He came to me for help. And
you know, with that, I didn't have a planned remark to this, but David used to send me the briefs and have me give opinions on it. So it wasn't like I was interfering, if I did in fact interfere, which I didn't, but regardless, I was part of, first of all, I thought he and I were partners in helping people. Obviously, I've been mistaken all these years. Secondly, when he would sell his materials and people wanted to talk to him, very rarely did David want to talk to anybody. He left it up to me. And what David, which I never bothered telling David, I helped a lot of people get the stuff resolved in the fashion that I know how, which wasn't arguing. But needless to say, I'm going to go on.
Okay, wait a minute.
Huh?
Yeah, let me talk.
Yeah.
So let's set the record straight. First of all, Data, when I got in, remember, here's the facts. Data did not know what to do. After Boggs was convicted, he says, I don't know what to do, Master Royal or Lamar. I need your help. I'd like you to come in and work as a team to assist us because I don't know what to do. So I was brought in. He brought me into this team. So when I came into the team and I met Boggs, and I already knew Chappie, but I was a part of, at least I thought I was a part of a team. And I thought that I would have a voice, you know, like we have conference calls, we talk about things, we discuss things. When he dropped me, he never called me. We were never on a conference call where we could discuss things openly. He just determined that he was just going to drop me because I interfered with his work in what he calls his office. But wait a minute, he'd already canceled himself on the case. He already said, I didn't know what I was going to do. I didn't know what to do. I didn't, I'm stymied, right? So I come in at this point in time. So now I'm involved, right? Richard retained me to come in and assist him. So if I'm coming in and I'm being paid as a consultant to come in and assist, doesn't it make sense that I have a right to talk about the case and talk about the motions? If David wants to prepare a motion, great. But you know what? I've got a lot of expertise here. I know what's going on. I've been doing this for a long time, just in fact, longer than Data, right? And I've got the victories behind me. So doesn't it make sense that we would be a team? Yeah. So when I put my input in, all of a sudden, he wants to take the case back over again. Once I explained to David how to win the case, all of a sudden now he's back in, he's trying to direct the case and telling us what to do, when everything he's doing was because I told him what needed to be done at this point in time and what we could do at this point in time, like the affidavits, like the jurisdiction motions. There's a lot of things we can do after the conviction, right? But he didn't want to hear it. And so he drops me because I stand up and say, you know what? These are the things we can do. And then he took my suggestions and now he's back in the case again. And even Chappie is supporting me. We're all working together, Boggs, me, Chappie, you know, trying to work things out as a team. But every time he'd come on the phone, he just wouldn't listen to any of us. And he wouldn't listen to
that's
anybody's
not being a team player, because our goal is to get Boggs free, not to
Absolutely.
get the pat on the back or the trophy. We're not looking for the
100%.
trophy.
100%. And so we were all acting as a team. And because we were a team player and we're all talking to each other, he didn't like that. He kept saying, well, Boggs is my client. Well, wait a minute. Boggs hired me. So does that, when someone hires you and retains you, doesn't that mean you're a part of the team? Right? And isn't it interesting that it was David Myrland that brought me into the team? And all of a sudden, now that I'm into the team making all these suggestions, now because I'm making suggestions and told him what to do, now he wants to take it over and say it's his office. I mean, how arrogant is that? It's unbelievable.
Yeah, it is. Okay, let me go on with the recording.
And I did it. Knocked it out of the park. And that just wasn't enough. And so Richard has taken lessons from Chris Chapman, who's never done any of this work, never written an exchange of briefs between him and the federal government, can't write a legal document. He's a businessman. And Richard chose
Okay, I'll get
to let Chris interfere, and they didn't even ask me why they shouldn't do what they did. And I replied to him with 3 words. I said, you're blowing it. And in the chat, here's what I got in response. I said, you're blowing it. And send. The response I got is at the bottom of that paste. He says, I disagree, but I'm not arguing this point with you further. Further? You haven't even told me about it till now. I decided to file the territorial jurisdiction motion, and I'm happy with my decision. Well, I'm not. The courts have struck that down a zillion times.
Okay, this is phenomenal what he just said. The court struck down a zillion times territorial jurisdiction. I would reverse that to say that the government has enforce territorial jurisdiction protection, not against it. And any comments? Okay, let me go.
No, absolutely. I have a comment here.
Yeah, go ahead.
Let's think about what he just said. In any court case, you have a right to bring up the jurisdictional argument at any time. Now, isn't it interesting that when David Myrland had the case in his hands throughout the entire trial, he didn't bring up the jurisdiction issues. So here we are after the conviction. What is the most important argument you could bring up at this moment in time?
Territorial jurisdiction, the only one.
Absolutely. It's the only one. It's the only one the courts will listen to. And you know what? I challenge anybody that's listening to this to do their own research, because there is a plethora of cases that the jurisdiction argument's been brought up and were won. It's the opposite. It's the complete opposite what he's saying. In fact, if any of you really want to get into this, you need to ask Boggs if he'd be willing to send you a redacted version of his motion that he sent, and take a look at the strength, the power of this motion and how powerful it is. Now, when we showed this to David Myrland, he freaked out.
Yeah,
Why? I have no idea. I have no idea. But you know what? Here's the interesting thing. He wouldn't come on any of the calls with Boggs and me and Chappie. So it wasn't us that was not informing him of what we're doing. We were doing the opposite. We were informing him of everything we were doing. But he didn't like the strategy. He didn't like the strategy that all of a sudden Lamar is coming in now and assisting Boggs. But you know what? It was Boggs who loved this argument. And I agreed with Boggs that this is the most important argument that we can bring in at this point in time. I worked with him. I helped with him. We assisted together. Chappie assisted. We all worked together in putting this motion together. It was not just Royal Lamar's brainchild. No, it was a team effort. We all assisted. And you know what? We even took stuff from David Myrland's stuff before, right? And put it in here.
Yeah.
And so it's probably one of the best territorial motions that I've ever seen in my entire life. It is really good, folks. And if you really want to see the strength of a team effort, you need to get a copy of this motion and take a look at it. Because if you read this motion and you read our memorandum of law that supports that, which is killer on itself, you will see the strength and the power of what we're doing.
And by the way, I do accept donations if you request. Okay, thank you. All right, let's move on.
So wait a minute, hang on 1 second. So
Yeah.
let me just add something.
This is Boggs, by the way, folks.
Yeah, I just want to make it clear that although we had two camps once David decided to separate himself from any participation as far as the rest of the team was concerned in preparing whatever we were doing or having any kind of discussions with it. I tried my best to keep David informed every step of the way of what I was doing, why I was doing it, and sending him copies. Now, this whole thing with the territorial jurisdiction motion, when we decided to do that, I had a call with David, and I was upfront, told David, this is how I'm proceeding. Because when push comes to shove, it's my ass on the line, so I'm making the final decision here. And if David wants to put his ass out there, then fine, I'll let him make the decisions all day long. But when it's my ass, I'll have the final say. I'll make the final decision. So I kept David informed the whole time of what we were doing, and this whole thing of they didn't consult me, they changed my stuff and all this kind of stuff. It is total bullshit. Now I'm just going to call it like it is. And so to say that he had no idea, I sent him a copy of the territorial jurisdiction motion before it was filed. He said, David, this is the motion. This is what we've got. Now, he didn't like it, and he was against it, and we discussed it. But I was firm in my conviction that this is what I wanted to do, and this is what I was going to do. And I told him that, and then he kind of seemed to be like, okay. He even made some suggestions to that motion, and it's
that's right. I remember you telling me that. I forgot about that.
He made some suggestions about stuff, and so he was involved from to say that we kind of blindsided him was filed. I mean, that's just not true. So anyway, that was just to set the record straight, to say that he didn't have any idea or he didn't have any input in what he was kept in the loop by me personally through the whole thing. And I gave him everything ahead of time, asked for his input, and all this. And yeah, I changed some stuff, and yeah, it pissed him off. He didn't like it. Don't be changing my stuff. Well, let me tell you something. It's got my name on it. I don't see David Myrland's name on any of this.
Yeah.
So if I want to change it, I'll change it. And I did. I made some changes to that it suited the way that I would present something, and it stayed in what I felt was consistent with my filings through the years. So, I tried to maintain that consistency and tried to maintain that particular personality in the things that I was filing. And he was very helpful, very helpful. And but to the very idea to lead people on and say that we did something behind his back, it just couldn't be farther from the truth. He was as involved as humanly possible through the whole process, even as difficult as it was. Once he decided to throw his little temper tantrum and separate himself from us, at that point, it doubled my work, because now not only I've got to do it, you know, with everybody else that's, you know, participating, but now I've got to, you know, do David's, you know, on the side, and then kind of bring everybody together. Now, nobody else was opposed to having conversations with David, included. Royal wasn't, Chappie wasn't, and I wasn't. David was the only one that was hell bent on not being included in the conversations. He wanted to only talk to me and me directly, nobody else.
Yeah.
So anyway, that's just wanted to.
Okay.
So wait a minute. One more point on that. And remember, David Myrland, at the time of the conviction, he'd been working with Boggs through the entire case. He was the one that was bringing the arguments up. He was one assisting and helping, et cetera, et cetera, et cetera. And remember, when the important point of the trial came up, he was subpoenaed to defend the Section 83 position.
He wasn't subpoenaed. No, he wasn't subpoenaed. Okay. So let's get that clear. Well, he was not subpoenaed. I offered to fly him in just to be here as kind of my expert witness on my side, should the opportunity present itself that, you know, we might could get him on the stand. I mean, holy cow, we had his book introduced as evidence. His name was all over the place, and I, you know, but anyway, he turned me down flat. So let's get that straight. He wasn't subpoenaed.
But here's the thing: if he's the expert, and he's the one who's been driving the ship for 10 years, and that expert is not willing to come to the case and defend his position, what does that tell you about the person himself?
Well, not only that, David and I have always said on the calls, we'd be glad to be a witness. You know, if you're willing to pay for our time and food and lodging, we'd be glad to become. And then the first time in all the years that I've been working with Dave, he turned the offer down. I was shocked, but I didn't say anything. I'm moving forward. I'm staying focused. I ain't got time to worry about his little problem.
Chappie was here the whole problem for a week.
Yeah. So I mean, David's lack of integrity. That's all. I mean, David asked for this call. Yeah, I don't like doing this, by the way, people. This really bothers me because I'm loyal to my friends. I think there's two guys that can admit to this here. I am loyal to my friends. I will do anything humanly possible in my realm to do what I can do. And I'm not, and I don't ask for a trophy. Okay, so it is what it is. Let's move on.
But if you have to, I'll go through it. And I found some mistakes, and he made some corrections. He goes on, now if you can't help and be supportive instead of this, you're blowing it bullshit, please stay out of our way. We will move forward without you. That's him and Chris. I've about had it with this bullshit, David. What bullshit? You don't want to know if you're blowing it? Because that's what you're doing. I want somebody to be supportive. I've lived your case for about a year. For pennies compared to what you paid those two criminal defense lawyers. And that's not support? I slaved over those pleadings. I'd have a motion on my desktop, working on it for 3 weeks to make sure the bases were covered. And back and forth with him, consulting, while I barely got paid for this job, and I'm not supportive.
Now, I want to say, you know, that bothers me, he does that, because over the years, when David needed money, whether it be, I'm not even going to talk about amount, but I will tell you, it wasn't $20. Okay. And he said, boy, I need this money. And I said, well, you know, you do a lot of work for Boggs, why don't you give Boggs a call? And he would. And Boggs would say, yeah, how much do you need? I would call Boggs up. I said, man, I'm just a little tight. And he said, how much do you need? And I shuddered to say, even ask, to say the amount. Boom, it was in my account immediately. So for him to say that Boggs never paid him and never anything, that is just a totally disgrace and inhuman of him to even say that.
And I'm not going to support mistakes. You're blowing it. He doesn't want to know why. You know what a header is? When you look at a legal pleading, it's got a footer down below that says motion to dismiss for whatever reason, page 6 of 7. You put a footer on your pleadings. You don't put a header. Why? Because the header, that's where Pacer is going to put the court's docket number.
Okay, now this is why I got this. This is what he's talking about. Does anybody see anything wrong here? Now let's look at the way the lawyers do it. Does anybody see anything different here? There's two things that are different. One is the lawyers got Division of Corrections, Columbia Division. And you see the numbers up here on the top. On the one that David is talking about, you see the numbers on the top. And they got motion to vacate judgment, lack of jurisdiction. That's the only difference right here, is these right here. Other than that, they're equally the same. So again, David is making false allegations. Move on.
When you file it onto the record. And so you don't use headers. Well, he used a header. They added a bunch of exhibits to the first motion, instead of waiting until your chance to reply to the government's opposition to the motion. You don't try to sandbag them first. You try to sandbag them after they have spoken.
Okay, now he's talking, how opinion on how to do things. And I'm not going to rebut, there's no sense in bringing that up. I like to give all my, like we talked earlier, put it on the board, let them rebut it. If they don't rebut it, that goes to my favor on the record. And David likes to keep it because why? Because he likes to argue. He loves to argue. And he argues, the merits of the case instead of just shutting it down. But, everybody argues their different way.
Now, here's the point, though. Nobody wins in an argument.
That's right.
So there's no reason to argue. What you do is you lay it down, you sign it under penalty of perjury, you make an affidavit to back it up, and you give the government their time limit to respond. When they don't respond, you back it up with an affidavit of non-response. If your position is correct, the government will never respond. Why? Because they can't, right? Because you're correct. And the only thing they'll say, well, it's frivolous or it's meritless. They'll use all these stupid words, right? But they're never going to directly attack your work if you know what you're doing.
Okay.
And that's the reason I dumped Lamar Hardy, is because he thought that's the way you should do stuff. And I said in a message to him, you really, when you consulted with Richard Boggs and your history, don't call me, don't text me, don't email me, your history.
I know Lamar must be biting the bullet again. He hired me. Oh, boy.
Absolutely, he hired me. Why did he hire me? You know why? Because he didn't know what to do.
Yeah.
The bottom line. And he brings me in after the client is already convicted. I mean, how stupid. Why not bring me in the real case? I mean, you don't think that he knew about me prior to working with Boggs? Of course he did. But he brings me in at the back end when he's done. He doesn't know what to do. And by the way, I was a paid consultant, so I am a part of the team. Right? Boggs personally retained me after he looked at my research and looked at what I did. And if I wasn't good at what I was doing and bringing merit to the case, Boggs is smart enough to dump me too, right?
Well, we are smart enough. In fact, after that call that David fired you from his law office, we teamed up with you and left him. I mean, I left him. I mean, I really didn't want anything to do with him. I didn't want to just walk away from him, because when you have a relationship like we've had over the years, a good business relationship, you just don't walk away. And fortunately, this came up where he threw me away, and I'm glad to go. But let's get on.
No, wait, real quick. The
So
bottom
Chris-
line is here. First of all, I'm involved in the case. I'm retained in the case. I've been hired as a consultant in the case. And who brought me in? David Myrland brought me in.
Yeah.
And so when we got on the conference calls together, he wasn't a participant. He didn't want to listen to anybody. He continued in the case as if he's a part of the case and it's only his case, when he brought in a team effort. And this is the way Boggs wanted it. Boggs wanted a team effort. He wanted to listen to Chappie. He wanted to listen to me. He wanted to listen to David Myrland. But the neat thing about Boggs is, and I highly respect him, is, you know what? Boggs is his own man too. And he's talented enough to look at all the issues, look at everything else, and decide what he wants to do. Now, sometimes when I made suggestions, he didn't like my suggestions. But you know what? I didn't have a hair day over it. No, I just said, you know what? Give me your opinion and what you think. And you know what? I listened to Boggs, and many times I agreed with Boggs. So I always took the position that Boggs is intelligent. This is his case. It's his life on the line. And based on researching everything that everybody's presented, he's savvy enough to go through it and pick out the stuff that he really likes, and he puts it in there. And you know what? I respect him for that.
Okay. Let's move on.
if he interfered in Boggs' case. It's in my law office. Richard Boggs doesn't have any experience except these civil lawsuits that he filed. I've been writing against DOJ back and forth, U.S. District Court and Appellate Court, and writing Supreme Court briefings. It's what I do. And
you know, I gotta say, yeah, he writes. You know, he has written many briefs to appeals court, Supreme Court, but of course he never won. In fact, he writes so well, he wrote himself into prison for 3 years and pled guilty to crimes he didn't commit because there wasn't a crime. The statute did not support his offense. But what did he do? The Almighty, what did he do? Pled guilty. I rest my case.
So here's a man who claims to be the expert who wouldn't even defend himself in his own case. Think about that for a minute. Okay, I've been in trial myself many times. Okay, and the one thing that's different, I defended myself all the way in. In fact, one case I was facing 7 counts of drug money laundering. Now, I've never done any drugs, I've never done any laundering, but here I'm involved in a case where I'm facing 140 years in the federal penitentiary. Now, you would think that someone's facing that much time that they defend themselves. And you know what? I did defend myself. The government forced me to take an attorney. There's a public pretender, never won a case before, but we spent 2 years working together as a team. And I'm sitting there educating this poor guy what to do all the way through. And you know what? In that case, we had 7 counts not guilty in front of the jury. Now that's what it means to go to trial and win the case. Okay, I've done that consistently over and over and over and over again. So the difference is he argues, but you know what? Every single argument that he's ever argued, he's never won any arguments even. Name one, right? You can't win in the argument game. That's called the racquetball game, right? You can't win. It's an impossibility. So if you can't win, why are we playing that game? Right? The only reason we're setting it up and using motions is to set up the affidavits and point to the real issues and focus the position where the government will not respond, and then we can attack the non-response. That's how you win cases. And for whatever reason, he has, in all his years of his so-called law office, which is not a law office, it's just a research like any one of us, he's never won anything. So he is not the expert that he says he is. He might be good at writing briefs and motions and everything, but you know what? If you can't write him to win, then you know what good is it?
Richard Boggs calls it bullshit when I point out that you're blowing it. You're blowing it the same way Lamar Hardy did. And so I responded to his email to say at the top of that, paste in the chat, best of luck and goodbye. I'm out. And Chris, we don't associate. Farewell. So Chris Chapman and I are history. He handled a lot of stuff for me, business-wise, sold my courses, satisfied the orders. But to consult on a case that's in my law office, when he's got no experience, this is my research, my expertise, my legal writing abilities, and here's what Chris thinks Richard should do without, for the sake of him getting an opportunity to meddle in my affairs. So now Richard Boggs won't have me to receive the government's replies to these motions I've written and to formulate rebuttals to their oppositions. Isn't that nice? Oh, and I'm not going to be around to write a motion for downward departures. And I'm not going to be around to write his allocution to say, go easy on me, I'm innocent, and everybody knows it. So he doesn't have me for responding to the government's opposition pleadings, and for writing downward departures, and for writing his allocution submission. And I won't be around to write his appeal, and I won't be around to write his clemency request. That's what Chris thinks he should do without, just so Chris could meddle in a case that I'm handling. That's not a friend. That's somebody who has utterly no respect for me and my experience and my obvious talents and skills. So, Chris Chapman. Fuck Richard Boggs. I'm not going to react to what somebody who has no experience.
He says he's not going to react. What do you think this is, Dave?
Thinks should be done to my work. It isn't going to happen. And Chris knew it 90 days ago when I dumped Lamar Hardy over the same thing. So, the Richard Boggs case is history. If he gets a victory, it's because of me. And if he loses, let's blame Chris.
Hear that? You know, it's his victory, not ours. Not all of us that, you know, he suggests that Boggs retain. No, it's all me if it's a victory. But if he loses, hey, it's all you guys, man. It ain't my fault. What a pig. I mean, that really gets me angry. So let me just shut up.
Well, let me talk then.
Go ahead.
So let's just look at the bottom line. Remember, when I got in, this is Lamar, when I got into the case, he was already convicted. Now, how did that happen with David Myrland running the show?
Yeah.
Right? So now he doesn't know what to do. So what does he call? He calls the guy that he knows that can win the cases. He calls the only guy he knows in the entire country that has consistently won case after case after case after case. And as far as a law office, again, he's not a law office. He might have some experience in writing briefs and everything, but so what? You can write briefs all day long, but if they don't do anything, who cares? Again, every single brief I've ever seen from David, even though they're very good, but you know what? What has it got the client? I've never seen one case ever that he's written motions in that it got the client anywhere. So, you know, as far as I'm concerned, you know, arguing, it just doesn't work. And I've told that to Dave many, many times. I said, you know what? You need to change your strategy because you're just wasting a lot of time. You're wasting a lot of energy. You're huffing and puffing, but you know what? It's going to go nowhere. And so when I bring in the affidavit strategy, and he says, well, let me see how you're doing the affidavit. So I sent him copies of my affidavit so that he could see the setup. And what does he do? He starts copying my work. And all of a sudden, it's his work. And then when he would do an affidavit, and I said, well, David, you missed out all the good stuff. You didn't put this in, this in, this in. I said, this is like you stripped about 95% of everything that I put in the affidavits. When I put it all back in, he gets really mad at me and he dumps me. Because I took the position that him copying my affidavits and stripping my affidavits out when I've consistently won with those words and those elements in there, and then he strips them out and wants to do it his way. And what did he do? He turned the affidavits into arguments.
Yeah.
Right?
He loves to argue. He loves to argue.
I said, David, this is an affidavit. We don't argue inside an affidavit. We state the facts, period, bottom line, right? And give the government a chance and an opportunity to respond. And if you know the facts, you understand the issues, you can easily write the affidavit so the government can never respond. They can't respond because you know what? You're standing on truth.
Yep.
Now, what's cool about Chappie is Chappie totally understood what I was doing because he had years of experience prior to that in other cases and stuff, and he used affidavits. Boggs himself had done a lot of affidavits. Oh my God, he did the framework years ago of putting the proper affidavits together. Now, they're not quite as good as mine, but that's okay. The very essence of what he did a great job 10 years ago of laying the proper affidavits.
And the bottom line, they never responded to him.
That's right. So they acquiesced. So we were able to take Boggs' affidavits and then reincorporate them into the affidavits that I suggested. And now we had something that's so powerful, it's unbelievable. And anybody out there listening, if you want to see some really powerful affidavits and some real cool language that we use and how we use to set these guys up, you need to talk to Chappie and get some.
Well, what they can do is go to Pacer and download it because it's but we'll go ahead.
Yeah, so that's the quality of our work and what we're doing. And we're not arguing anymore. We're tired of arguing. It didn't get anybody anywhere to argue anything. So why are we arguing? We have to change the strategy to win the case. And again, the odds of winning a case after somebody's convicted is, I mean, it's like probably going to Vegas and trying to win in a slot machine, right? It's very, very difficult. So there's only a few people in the entire country that could actually do this. And so I was brought in by David. Keep in mind, I was brought in by David. And so when I'm involved and I'm a paid consultant, doesn't it make sense that I would have the ability to communicate and work with the team and ask Boggs, am I a team player? Ask Chappie, am I a team player? Do I allow everybody to participate and work together as a team to be able to do this? I never say that my way is it or it's the highway. No, I allow other people to use their intelligence, use their skills, use their abilities, and we all participate as a team. And when you participate as a team and everybody puts their input in, oh my God, you really get some powerful tools that people can work with now.
Yeah, and and talking about a team and support, like Boggs from day one, there's things that I suggested that he elected not to do or failed to do it. And I never, got angry with him. He never got angry at me. We learn by our mistakes and we turn around and correct them. And that's what we need to do. But that will never happen with Dave. Dave's got to blame somebody. But we're almost done with the recording. So let's go forth.
But one other thing, really quick there. He says that if he wins the case, it'll be because of him. No. Guess what? He had his shot at the case, and guess what? His expertise and him not showing up got this poor guy convicted. So let's just set the record straight. Everything that he did didn't win the case, didn't stop the case. The government moved forward as if he didn't even make a move. And so everything that David has attempted to do to assist on any level on this case, none of it has worked on any level. So let's
go ahead. I'm sorry.
So let's just be frank with what's going on here, right? And the strategies change because the issues and how David brings his stuff to court isn't working. It never did work. In fact, it's impossible to work. You can't win an argument.
Yeah.
And so we're trying to close the case. But if you notice very carefully to everything David said, he was participating as if Boggs was being convicted. That's not what Boggs wants. Boggs wants to shut the case down, period. He doesn't want the case to move forward. We're not interested in allocation. We're not interested in working with the sentencing people. We're not interested in any of that. We want to shut the case down. Why do we want to do that? Why do we want to do an appeal? We want to shut the case down. We want to win now.
Exactly. Yep. Okay, let's move on. And
because there's a whole bunch of remedy laying right in front of Boggs, and they don't know how to access it effectively. So the best thing in the world for me to do is retire from law, but to retire the way it happened is the worst possible way it should happen. This is going to be the pinnacle of all of my efforts.
See, the pinnacle of all of my efforts. The focus is on him, not Boggs, but the focus is on him. This is a narcissist, boy, I tell you.
But yet the pinnacle of his case, he lost the case.
Yeah, he did. He lost. Well, you know, we keep saying that, but don't forget, Boggs is actually the one that lost the case because Boggs, you know, my suggestion was don't get attorneys, man. Stand on your own 2 feet and so forth. And David, on the other hand, oh, you know, hire an attorney and we'll talk to him and blah, blah, blah. So, and Boggs being under stress, I get it, man. I understand what he did and why he did it. I'm not blaming Boggs for getting an attorney. Who knows? If I wasn't as confident and as I am, I probably, you know, I don't know what I would do. However, I was confident enough to do what I did. That doesn't mean everybody, you know, Tom, Dick, and Harry out there is going to do the same thing that I did. I don't expect it. And I don't expect everybody to do what Boggs did. But the fact is, the minute he hired an attorney, he was on the road to being lost. And David, the attorneys had all the evidence and would not argue territorial jurisdiction, which I previously had mentioned as to why. And in future calls, we're going to be talking about this, not particularly the Boggs case, but what we learned from it, what we learned from my case opposed to Boggs's case and Gene Warner's case and all that. We'll go in more detail on that. But David, I was always against David suggesting they get attorneys. But David argues like an attorney. He ought to be an attorney. And if I didn't know David so well, I would think that he's working for the government. That's how bad it's got. But you know, that's a terrible thing to say. But it's true. It's just the way I feel.
Well, in my case, though, in every single case that I've done, except for my bankruptcy cases, we always had attorneys, but you know what? We always won the case too. So
because
again,
you had attorneys that were willing to do what needed to be done.
Well, attorneys are attorneys. Remember, most attorneys are practicing. They really don't know. They promise the moon, but you know what? In the bottom line, once they get your money, they're going to sell you out.
Yeah.
So it's a matter of, if you have a client, it's a matter of what you file with the attorneys and work with the attorneys to give them the information they need so they can get the case dismissed or get a not guilty verdict. And so in every single case I've ever done in a criminal case, we worked with the attorneys, we gave them the information they needed, and we got the not guilty verdicts.
Yeah, Boggs
So-
is a Boggs attorney sort of conditional acceptance letter. Oh, that's sounds a little patriot-ish, you know? And you see how they turn the word patriot around. Patriot's what made this country. But now if
Right.
you're a patriot, oh man, you're a right winger. Yeah. Yeah. Okay, let's
Well,
move
again-
on. We're almost done.
Well, one other point, you know, when we came into the bottom line of the case and the back end of it, the goal was to file the right type of things that we knew that would have the strength and power. Now, we couldn't do it with having the attorneys there because the attorneys cannot file these type of motions. They're part of the club, right?
Yeah.
They're part of the system. So we talked to Boggs about getting the attorneys off the record and getting them dismissed. And we had to spend the time to be able to do that. And we were successful in doing that. And now we can file the things that are necessary, right? That couldn't be filed before, because the attorneys will never file any of these motions. They're not going to file the affidavits. They're not going to file these jurisdiction motions. Why? Because they can't.
In fact,
they're
they were
part of the
given
club.
to them and they refused to do it.
Absolutely. So
Yeah.
we had to get them dismissed, and we spent the time and we got that done. And now Boggs is in a position now to file the correct things that he needs to file to get the case dismissed.
Okay, let's move on.
To bring all my talent and research to bear against the DOJ in fine fashion and hope for a win, and then appeal and hope for a win, worst case scenario if they went through and sentenced him. And now the judge knows he's not working with a professional anymore. Something's happened. This pleading looks terrible. The strategy is moronic. And so the judge knows he's naked. And he earned it to consult with Chris and change my pleadings based on Chris's suggestions. So yeah, they're both history, and one last. So you won't hear me talking about the Richard Boggs case or Chris Chapman because they're history. I retire.
Okay, that's the end of the recording. And real quick, as we're doing it, here is, in my case, when, hold on a second, there's a message in the chat there. I keep saying my law office, I will get the case trouble. Okay. Yeah. That's true. Let's see if let's see if the text says he keeps saying my law office. That will get his ass in trouble for practicing law without a license. Yeah, and he'll plead guilty. Okay, here's a legal sham of process that I filed. Now, I want you to know I had help. I had a team. It wasn't Dave Myrland, although Dave was, I used Dave Myrland's criminal complaint, but Dave had nothing to do with this. And when you go through this, it's a criminal complaint naming everybody. I mean, not a criminal complaint. It's a affidavit of sham process. And it goes on and it's all about Title IV, Section 72. It's all about territorial jurisdiction. Then I did an abatement. The abatement should always be before you plea. Okay, if you're pulled in to court and they want you to plea, you plead to the jurisdiction, and you want to challenge jurisdiction. Because how can you plea until jurisdiction's on the record? And this here is a 48-page. And David knows about it. I told him I did it. And at that time, he had just met me. You know, a guy that doesn't know what he's doing, doesn't know anything about law, as he says. And I'm not submitting that I know everything and I'm a legal whiz. I'm not. I had, let's see, I had Jack, I had JR, or RJ rather, excuse me, JS. I had about 7 people helping me put this together. And it cost me and it cost me a bunch of money too. But the thing of it is, guess what? I didn't hear anything. We got a little background noise there. Can you mute yourself out there? There you go. And so here is the conclusions and so forth. And then the show cause. I was pulled into court to show cause why I should not be held in contempt. Then the judge's order. Now, I want to make a point here. Here's the judge's order making me do something, okay? And when she told me to go, that I am going to do the exemplars of the following, excuse me, I just lost the document here. That I'm going to do the exemplars. I said, look, what else would you have me do under fear, threat, and duress of going, under threat and fear of going to jail? What else would you have me to do? And I said, but I'll do it as soon as you give me a written order. Well, she faxed me an order. Now, notice this. On January 13th, at 5 a.m. in the morning. That's the day I saw her. That's the day I appeared in court at about 10 o'clock. But on but that morning at 5 a.m., she made this order out. Now, what does she have? A crystal ball? Chris Chapman's going to come into my office, in my courtroom today at 10 o'clock. He's going to say this, he's going to say that, and I'm going to write this order. So when he comes in, this order is going to be written and then files it onto the record before I get there. Okay? And the grand jury direct Mr. Chapman to appear before it. I never refused. I conditionally accepted upon proof of claim to the jurisdiction by which they never provided. And then I did we still got background noise. Chapman again appeared before the grand jury again. The day I arrived, they asked me if I was ready, and I said, yes. Do you have the answers to my question? See, I stood my ground. I never waived until they showed jurisdiction, which they never did. And I never heard back from them. And then they told me to go home. And I told them, no, I'm here to comply. And he argued and told me to go home. So I turned around and went home. And so the hearing was set on February 13th, like I said, and I argued Title IV, Section 72, and she never read the case because she brings up the Hughes versus the U.S. It's right out of their playbook. Whenever you argue Title IV, Section 72, they bring up the Hughes case. And yet David Myrland has the response right in his criminal complaint memorandum of law to the criminal complaint, which now he refuses to acknowledge. Go figure, people. I don't know. But anyhow, I'd like to thank everybody for listening to this call. I feel bad that it had to happen. Originally, when David wanted to get rid of me, people were asking, "Hey, what happened?" And I said, "It's just between Dave and I. I'd rather keep it that way." And I said, "I don't like to put the dirty laundry out in the street," but he's the one that made that recording and got it on TalkShoe. And so I just wanted to respond to the allegations and how I knew David had some questionable situations for me to be concerned about, but I was willing to have a blind eye on it because that's what friends do, right? They kind of ignore people's faults and go with the value of the person. But it turns out to be now, I made a wrong decision. The man has no value. He has no value whatsoever at all. To lie and defame other people when all they were trying to do is help somebody, and his best that he can do is call them names. I think that, and lie about them. So David, you asked for it. You have a good life in retirement. I'd like to thank everyone. Any last comments from
Yes.
Lamar, or
Yes.
go ahead?
The bottom line is this. Remember, he said that if he wins the case, it'll be because of him. And that's just absolute lie. Because number one, it's not going to be about him at all. Because you know what? He backed out of this case. He backed out of the case when Boggs was convicted. So everything after the conviction, when I come in and we work together, we've changed the strategy. Why? Because arguing doesn't work in any case. And to say that I don't have any intelligence and I don't have any victories, come on, David. I said, I'll put my record up against your record any day of the week, right? Show me all your victories because I'll show you all mine. And the bottom line, I've never known Dave to win any cases in all his arguments. Now, that's not saying he doesn't know legal stuff. He does know legal stuff, right? He does understand a lot. But when it comes to winning a case, that's what he doesn't understand. And again, the bottom line is in his own personal cases. What did he do? He pleaded guilty. Why? Because he doesn't know how to defend his own position. So if a guru out there is saying that he's an expert, when his own trial comes up, he pleads guilty to the case and doesn't even challenge any of the issues to the government. What does that tell you about the man? When he's asked to come to court and defend his position on Section 83, and he refuses to come, what does that tell you about the man? When he won't become a team player, when people are paid to come in and assist and work together as a team, and he doesn't participate as a team player, what does that say about the man, right? So the bottom line is, if we win this case, it will not be because of David Myrland. It will be because of the strategies that the team, and I'm talking about Chris Chapman, I'm talking about Boggs, I'm talking about myself. We come in together as a team. We're all benefiting from this. We're all assisting each other. We're all respecting each other. We're honoring each other, and we're using our gut sense, right? We're not trying to participate and go to the appeals court. Why would we want to do that? We're not wanting to go to allocation and all these things that he wants to do. Screw that. Let's get the case dismissed, period. Bottom line down. Let's get it over with.
And I'd like to add one more that brought a lot of strength and help is a guy named Boris.
Yes, absolutely.
Boris is awesome.
Yes, he is.
All right.
And he understands the territorial jurisdiction argument very, very well. He realizes that that's the strength. If the government doesn't have jurisdiction, they don't have a case. It's just that simple. So why are we arguing anything else but that? Let's just focus on what needs to be done, folks.
Okay, look, Richard, do you have anything to add?
Nope. Thanks, guys.
Okay. All right. Well, I'd like to thank everybody for coming on the calls. I'm feeling a heck of a lot. I was telling the guys earlier, I don't know if it's more Minto that I'm taking that is changing my mitochondrium up. I can't even speak. I'm so excited, but I'm feeling a lot better now, and I don't know if it's the stuff that I'm taking or that I got the depression off of my back of Dave Myrland, because just to see his name pop up on the call, I realize now. I didn't realize as much then as I do now, that when I used to see his name on the call, I said, "Oh God, I got to listen to him." And that's a terrible thing, the way to feel. It's my fault. I should have ended this arrangement with him years ago, but I didn't. So with that being said, God bless America. This call is now officially over. Thank you.